All right, so I started handling these FELA cases about in 2007. I had a referring attorney that called me up, and he'd been doing them for decades, and he wanted some help with a few of them. And I had never, beyond taking a quick look at the jury instructions in the 160 and 170 series, never really known anything about FELA cases back at that point in time. And you know, I was always under the impression it was more or less workers' compensation with a jury, and you get all your damages. And I started looking at it and researching a little more, and found out that there's no assumption of the risk. They've got pure comparative fault. You're able to get all the damages. You're not limited by, you know, the comp statute or anything like that. There's a potential for strict liability. So I'm thinking this is a good business decision. I'm going to start getting into some of these cases and see what I can do. And you know, they are good cases. But the thing that you got to remember here is you're dealing with the railroad. And in my experience, there's not a more difficult defendant to deal with, because they have as much money as they could ever spend, and they'll spend it to beat you down. They have no soul. You look across the country, there are more sanction orders entered against railroads than any defendant. They have no problem hiding evidence, changing evidence, lying about the evidence. And they can pick and choose which cases they want to try and which cases they want to settle. First two cases I tried were I thought were pretty good cases, and after the jury came back, I was my thoughts were proven correct. But they offered me no money on both of these cases. I'm thinking, what the hell am I doing wrong? I feel like I beat you up all the way through discovery, all the way through trial, and you should be paying me. What I'm getting at is it's terribly important in these cases to know, probably more than any other case, that this is a case that you have to be prepared to try, because you're never going to know when they're going to pick up the phone and say they want to settle it. You absolutely have to be prepared. So what I'd like to do is kind of give you a little bit of an overview of where this law comes from. One of my concerns when I first started doing this is the word federal is in the title of the statute, and I feel most comfortable walking around the 22nd floor of the Daly Center. So I wasn't quite sure what I was getting at. So let me give you a little bit of an idea. This isn't quite as smooth as everybody else's PowerPoint, but the meat and potatoes of the FELA are contained in the United States Code. And as a little civics lesson, the United States Code, these are laws that are enacted by the Congress. And we're going to talk a little bit about the Code of Federal Regulations, which are regulations that various different federal agencies have promulgated by virtue of the power that's been given to them through Congress. And so the meat and potatoes of the FELA begins at section 51, 45 U.S.C. 51. And then it continues down through section 60. There's a number of other areas of law that I'll point you to, but right here, this is kind of the meat and potatoes. And so I want to take a look here at 51. And there's a few different portions of this that are particularly relevant to anybody either handling their 50th case or screening their first FELA case. You need to know who your defendants are. It's not every single person that pulls a train in this country that's subject to the FELA. You have to be a common carrier in interstate commerce. For instance, locally, you think about, we have tons and tons of rail traffic here. The big four, your CSX, Norfolk Southern, Canadian National, UP, they're all going to be subject to the FELA. The question with them becomes when they have some of these subcontractors, people that are actually doing the work for the railroad that aren't necessarily employed by them, whether you can bring them in. And I'll talk about that. It's definitely in the materials, and I'll try to get to it. The CTA, they've got trains. Are they subject to the FELA? No. They don't operate in interstate commerce. Their rail system is entirely within the city of Chicago and the various counties just outside of it. Metra, I do most of my work against Metra. Metra is in interstate commerce, and as far as I can tell, the only reason is because they have a little bit of trackage that goes into Wisconsin and a little bit where they connect up with the NICD in Indiana, but they're subject to the FELA. So if there's really a question as to whether they are or they aren't, you could probably figure out pretty quickly by just going to the clerk's website to see how many times they've been sued, because if it's not going anywhere, they're going to get bounced to comp. Who are the plaintiffs in these cases? This was something that, when I got into this, I'll be honest, I didn't know how the railroad worked, and I had to spend a lot of time teaching myself exactly what was going on here. And you've got there's anybody that works or affects interstate commerce within the railroad can be a plaintiff in an FELA case. Your typical people are your locomotive engineers, your conductors. There's a classification of workers called carmen who work on the cars, sometimes work on the locomotives. You've got other tradespeople, electricians, laborers, folks like that. But it even extends out even further. There's a relatively infamous case here locally where there was an attorney, an in-house attorney for Metra that tripped and fell on an electrical outlet in her office. And that was held to be compensable under the FELA. So it's as has been referred to many times throughout the jurisprudence. It's a broad remedial statute. Congress recognized back in the early 1900s that there were hundreds of thousands of people being killed or maimed working for the railroad, and they needed to do something about it. Those folks didn't have any sort of a remedy, and so they created this broad remedial statute. In terms of the damages that they're subject to, really you get the full cup of justice, as I would call it. The only thing that you would get in regular tort that you can't have here, as far as I can tell, is a loss consortium claim. So the wife doesn't get that claim, which I don't know how, in the death case you can, but in a simple injury, you can't get the loss of consortium. The real key to the FELA, as far as most people look at it, and certainly how I do, is the relaxed causation standard. And if you look in this line here, it starts 4 from the bottom up, and it states, resulting in whole or in part from the negligence. They made the causation standard as broad as they possibly could. And the way, not in Illinois, but in the federal court jury instructions, the way they read, they even throw this little part in there, even the slightest. And that reading of the case law has created just an extraordinarily broad remedy. And one example, there's a case called Gallick, Gallick, from the Supreme Court. I think it was back from the 40s. And there was a worker, he worked in a yard, and the yard had some significant flooding problems and just water drainage problems in general. And this guy worked in this area that they kind of referred to it as a cesspool. There were rats that had died and were living in there, and there was mosquitoes that were coming up from this thing. And the guy got bit by a mosquito. And unfortunately, he caught a terrible infection. He ended up losing, I think it was both his legs. And the case goes up. It was tried. He got a jury verdict in his favor. And I believe the appellate court overturned it. And it ended up going up to the U.S. Supreme Court. And the U.S. Supreme Court says, we respect the jury verdicts in these cases more than anything. It's the Congress, when they enacted this statute, recognized how important it was for juries to decide these matters. And I think the language is, if the proofs justify the verdict in any way, it's going to be upheld.